Did you know in 1995, US granted a patent for using turmeric or haldi to heal wounds? This is the actual patent document. The patent was granted to University of Mississippi in USA. But how can this happen? Because the healing properties of turmeric were not a new invention. Indians are already using it for thousands of years. But this was not a one-off case. In early 1990s, a multinational chemical company, W.R. Grace, tried to patent Neem plant. In 1997, a US company patented basmati rice. In 2003, a company called Monsanto patented a variety of wheat that was grown by Indian farmers for thousands of years. In this video, I am going to show you how Western corporations tried to claim ownership over Indian heritage, how patent laws were weaponized to exploit the developing world, and how India went on an offensive to take back what was always ours. Welcome to the second layer. For the last few centuries, the world was ruled by colonial powers. British exploited spices, cotton, tea, indigo from India, palm oil from Africa, and sugar from Jamaica. The Spanish Empire, for example, mined silver from Bolivia, gold from Mexico, and sugar and tobacco from South American countries. Now, while taking away these resources, no benefit was given to the local communities. For example, if British Empire took spices from India, British Empire kept the whole profit, not Indians. But when the modern patent laws arrived, these developed countries weaponized the same patent laws to essentially do the same thing that they were doing before. That is, profit off the resources and biodiversity that is present in their colonies. There is a word for it. This is called bio-piracy. Now let's go back to the turmeric case. In 1995, the University of Mississippi Medical Center was granted US patent number 5401504 for the use of turmeric in wound healing. Now they claimed it was a new invention. Now if you're an Indian, you're probably laughing. Turmeric or haldi is in every kitchen. It is applied to cuts, it's applied to burns, it's even used in beauty creams. In fact, it is used by us Indians from thousands of years. So how did US Patent Office approved this patent? How did US Patent Office miss this? They missed this because whenever a patent application arrives in front of a US patent examiner, the examiner looks if this is an actual new invention. Now this means searching through published scientific papers and journals which are usually in English, and understandably so. But things like healing properties of turmeric are either present in old Sanskrit texts or even passed down orally, meaning some of these things may not even have a written record of them. So for the American legal system, it doesn't exist. Now this haldi patent sent shockwaves in India. The India's Council for Scientific and Industrial Research, or CSIR as it is called, decided to fight. They dug up ancient Sanskrit texts and crucially a 1953 paper from the Journal of Indian Medical Association proving that we Indians as a society already knew about the healing properties of haldi. In 1997, CSIR won. The US Patent Office revoked the patent. Now this was a landmark victory. Why is that? Because it was the first time a developing nation successfully defeated a US patent based on traditional knowledge. But for the bio-pirates, this was just the start. Take the example of Neem tree. Neem is a Hindi noun which is derived from Sanskrit word neem. Neem leaves contain a chemical called azadirachitin. Now, this chemical is harmless to humans but toxic to insects. In India, that is why neem leaves are kept in rice and wheat containers so that insects stay away from grains. Its oil has been used to treat skin issues. Neem seeds are also crushed to form powder, then soaked in water overnight, which is then sprayed on crops, and it acts as a natural insecticide to protect these plants. Indians even have used it as a toothbrush. Now, in the early 90s, the multinational chemical giant W.R. Grace isolated this azadirachtin and filed a patent for this in the European Patent Office for method for controlling fungi on plants by using neem oil. Once again, India had to fight. Indian environmentalist Dr. Vandana along with CSIR challenged this patent. Now they argued that the antifungal property for which W.R. Grace was granted a patent was already known since centuries and commonly prepared in Indian rural areas. Its derivatives were extensively used as low-cost antibiotics and antifungals. Now think about this. If this patent was not revoked, no medicine having neem oil could be sold without paying a royalty to W.R. Grace, an international American multinational corporate, which would have made these Indian medicines very expensive. Now this battle with W.R. Grace took 10 long years, but finally this neem patent was revoked by the European Patent Office. It was a victory, but it revealed a terrifying problem. Fighting these cases one by one costs millions of dollars and takes years. India needed a better strategy. Now, even though we were able to protect our traditional medicinal knowledge, modern world health costs are actually not cheap. Just look at the medical inflation rate in India. It is around 13 to 14%, much higher than overall inflation rate. Here, a good health insurance is obviously mandatory, but think about it, why you still haven't bought one? Now, I have realized the real problem isn't insurance itself, right? It's the lack of clear, simple guidance before choosing the policy. That is why you should check out Ditto Insurance free masterclass series on health and term insurance. Now, it's a 2-day live interactive session of just 60 minutes each, and day 1 is on life insurance, day 2 is on health insurance. Both of these explained in simple English. Now, during the 2 days, they will cover everything from how to choose the right plan to common mistakes that people should avoid while buying insurance. And most importantly, they will explain real-life claim stories so you can effectively learn from them. Now, I trust Ditto because they are a Zerodha-backed IRDAI certified platform, and over 50,000 people have already attended their masterclass. So register for this free masterclass using the link in the description or by scanning this QR code. And remember, since this is a live and interactive class, slots are limited. Now, back to the video. While the turmeric and neem cases were about medicine, the next wave of biopiracy was even more dangerous because it targeted the food security of India. Multinational corporations now wanted to own the very crops, very plants that you eat. Let's talk about Monsanto. In 2003, Monsanto was granted a patent in Europe for a specific type of wheat. This wheat had unique gluten properties that made it perfect for baking crisp biscuits. Now the interesting thing is the same wheat plant called Nafal is grown in Uttar Pradesh. And since Monsanto patented this exact variety of wheat, India had to act. Bharat Krishak Samaj or Community of Indian Farmers challenged this patent, and in 2004 the patent was revoked. They argued that the invention, that is, the traits that make crispy baked biscuits, was merely the expression of the Nafal wheat's natural properties. It was not an invention by Monsanto, and that is fair. Monsanto didn't invent this trait. But again, this showed a massive risk. If corporations can theoretically patent seeds' natural properties, they can legally stop farmers from planting those specific seeds. Do you understand the danger right now? And then there is this case which makes absolutely no sense whatsoever. In 1997, a Texas company called Rice Tech got a US patent for basmati rice. And they didn't just patent a new seed. They essentially tried to claim ownership of the name basmati itself. They marketed their own rice as Texmati. Now let's understand what is basmati. Basmati is a variety of rice which is long, having a minimum length of 6.61 millimeter, and it's thin with a maximum width of just 2 millimeters. Today, 65% of basmati rice is produced by India and the rest 35% is produced in Pakistan. So a US patent on basmati rice was a direct threat to India's economy. If Rice Tech, which is the company, tried to enforce this patent on India, they could potentially block Indian basmati exports to the US or even force Indian farmers to pay royalties to grow a crop that in fact Indian ancestors sort of developed. So India fought back hard. India prepared evidences up to 50,000 pages of documents and submitted them to the US Patent Office, proving that the traditional knowledge and the biodiversity associated with basmati was actually cultivated for centuries by Indian farmers. After a 3-year-long legal battle between the governments of India and the United States, US Patent Office had to finally revoke the basmati patent of the company Rice Tech. Later, India and Pakistan also obtained GI tag or geographical indication tag for basmati rice, which means only rice that is grown in the regions of India and Pakistan can be legally called basmati. Legally called basmati. For example, only sparkling wine from the Champagne region of France can be legally called champagne. For example, only tea grown in the Darjeeling Hills of India can be called Darjeeling tea. This is what GI tag or geographical indication tag means. But now, India realized that playing defense wasn't enough. India cannot afford to spend millions of dollars every time a foreign company tries to patent something that is traditionally known to every Indian. So India built a digital fortress. Now this digital fortress is called the Traditional Knowledge Digital Library or TKDL. The Indian government launched a massive project to digitize over 5 lakh ancient medical formulations from Ayurveda and Yoga. Each piece of text was read, then the medical formulation was identified, and then it was saved in a digital database. But they didn't just scan the books. They translated this knowledge into 5 international languages, namely English, German, French, Japanese, and Spanish. Now when a patent examiner is examining a patent, he or she can look at TKDL database in their computer and find out if the patent in front of them is actually a new invention or not, and then take an informed decision. And TKDL, that is Traditional Knowledge Digital Library, has been a game changer. So far, globally, close to 370 patent applications have either been rejected, set aside, withdrawn, amended, abandoned, based on the prior art evidences present in the TKDL database. Even the cost of fighting foreign patent applications has reduced considerably. Think about this, India spent 7 crore rupees for fighting the basmati patent by Rice Tech. Then, India also tightened its laws. In 2002, India passed the Biological Diversity Act. Now, this law made it compulsory for foreigners to get permission from India's National Biodiversity Authority or NBA before accessing biological resources. Now, in 2009, when Monsanto created Bt brinjal by using Indian brinjals and crossing them with Cry1AC gene, they did not take permission from the National Biodiversity Authority, which they should have because they're using Indian brinjals. Because of which, criminal cases were filed against them in the Karnataka High Court. Now, this Biodiversity Act basically said biopiracy isn't just a normal patent dispute anymore. This act made this normal patent dispute into a serious crime. But as India builds its digital library, corporations are changing their strategies. We are entering into the age of digital biopiracy. In the old days, a researcher or a scientist had to physically smuggle seeds or leaves out of the country. Today, they don't need the seed, they just need the data inside the seed. So what can scientists do? Scientists can now simply sequence the DNA of a plant and upload the code onto the internet. This is called Digital Sequence Information or DSI. A corporation in US or Europe can download that code, synthesize the active chemical in a lab, and create a medicine without ever touching the plant or even visiting India for that matter. And because they didn't physically take anything with them, can you still charge them under Indian or international laws? I am not sure. But the point is, the law is trying to play catch-up. Very recently, in October 2024, a UN Convention on Biological Diversity was held in Cali, Colombia. Here they created a Cali Fund. The idea is to charge a fee, let's say 1% of profits or 0.1% of revenue on companies that profit from this digital sequence information or DSI. This will then be distributed to countries or communities whose DSI was used to make a new drug, new chemical, whatever. But by 2025, the sad part is this fund was largely empty. because of lack of clarification and if this contribution will actually save them from legal disputes in the future. Then again, there is one more final loophole that these corporations have, and that loophole is international waters. Nearly 2/3 of the oceans today is international waters. Now, if you find a plant in the international waters, who owns that plant? No country has ownership there. Recently, BBNJ treaty was passed in the United Nations, which basically said this: if a company finds a gene in a deep sea animal, for example, some parts of the profits and some part of the research needs to be shared with the world. Is it effective? I don't know. Time will tell. So the question is, why does West want to own Indian medicine? Simply because countries like India, Brazil, Africa, they have a huge range of biodiversity. There is a good chance within this biodiversity, a cure for cancer is hidden. A secret to unlimited food supply is hidden. India has successfully transformed from a victim into a global leader in this intellectual property defense with tools like TKDL as we discussed. But now, from defense, we have to move towards actual innovation. The good thing is, unlike many countries, we already have the raw material which is extremely rich biodiversity in our country. If you enjoyed the video, hit the like button and don't forget to enroll in the free insurance masterclass by Ditto by clicking the link in the description or by scanning this QR code. Let's meet in the next video. Thank you.